Welcome to Law for Life with Georgia.
Welcome back to Law for Life with Georgia, where attorney Georgia Konstantakis brings nearly 3 decades of Wisconsin legal experience to help her community stay informed, protected, and prepared for whatever life brings. I'm Leanne Lyon, and today we're unpacking probate. Georgia will, now not everybody gets excited about it, but Georgia does. And Georgia will explain what really happens after somebody passes away in Wisconsin and why it can take months to finish and how simple planning can spare your loved ones from the hassle. Good morning, Georgia.
Good morning, Leanne. How are you?
Wonderful. Georgia, in Wisconsin, when people ask you what probate is here, how do you explain it in simple terms?
Well, in simple terms, when someone dies and they die with just a will, or if they die without anything, so that's called intestate. When that happens, you would have to go to probate if the assets are over $50,000. So that is a huge earmark. If your assets are over 50, in order for the beneficiaries to receive those assets, you need to go to the court and open up an informal or formal probate in order for those assets to transfer to you.
And what are the typical assets that are included in figuring out that 50,000?
A house is first and foremost. Most people who do pass away do own a home at that point. The next asset would be any bank accounts. So if those assets total 50,000 or more, you would have to go to probate in order for those assets to transfer. So you've got bank accounts, insurance policies where there are no beneficiaries named, uh, portfolios, brokerage accounts, mutual fund accounts, annuity accounts, any asset that you have that is in your name, titled in your name. In order for that asset to be transferred to your beneficiaries, a will is obviously not enough. You need to either A, name a beneficiary, or B, create a trust.
Well, I mean, throwing a house right in there, it pretty much means everybody would end up in probate. There's very few houses that are less than 50,000, although the value of the house could be potentially. When somebody passes away, then what is the main job of court during probate?
Basically, the court is there to make sure that first of all, you have to have a personal representative. That's typical of it's the same thing as an executor. What the executor will do in that case, they're going to be appointed by the court to be able to administer the assets of the estate. So that's what a personal representative will do. And if you died intestate, unfortunately, you're going to have to post a bond because that person could, who's to say, very easily abscond with the money. So a bond is posted in those instances so that that person is bonded, insured, and they don't have any issues with taking the money and just putting it in the pocket, so to speak.
Who is
So
responsible for posting that bond? And how
it's
much would it be?
typically, yeah, good question. Typically, the personal representative who's assigned to it, they will ultimately get reimbursed, but
Mhm.
in the beginning, they're going to have to front the money to post a bond. And there are requirements. Not anyone could just be a personal representative. There are certain questions that, if you obviously don't meet those, you would become disqualified. So
Wow, that
there is a
sounds like a
criteria.
hardship. That sounds like a hardship right up front. You've just lost
It
somebody,
is.
and now you have to post a bond. That's tough. For families who have just lost somebody, what is the very first thing they need to do before they open up the estate?
That's a good question. A lot of people will ultimately pass away at home. You would, at that point, contact the funeral home or wherever it is, whoever you decide to use at that point. And then the funeral homes are really good about navigating you through this process. Uh,
Wow.
Obviously, it depends on how the person passed away. If there was any malfeasance involved, obviously you would contact the authorities. But if they, for example, had a heart attack, then at that point, the next step would be to contact a funeral home, and they'll navigate you through the process of getting a death certificate, of at that point, either cremating, burying, whatever the case might be, and just following the wishes of the deceased person.
So, are you saying that the funeral homes can be a good starting point towards uh, moving towards probate?
Yeah, well, funeral homes start the process, but attorneys really are there to navigate everything. So,
Yeah.
in my in situations that I have, typically the client will call me, and I'll let them know that they first need to contact the funeral home and get in touch, obviously, with the rest of the family, make sure everybody understands, what happened, the person passed away, and then from there we kind of navigate through that probate process. But that initial encounter at the time of death would be that. And one of the big things that a lot of people don't realize is Social Security. If they are receiving Social Security, that needs to be cut off from the date of death. And I've had situations where Social Security wasn't informed for months later because the client didn't call us months later until after the person passed away, because they didn't know that they had over 50,000 in assets, and they had to pay back the Social Security office from the date of death of whatever money was put into that bank account. Because a lot of people will have their Social Security checks automatically deposited into a bank account.
Wow, that would be another hardship on a family in that
Absolutely.
situation. So, about how long does probate usually take in Wisconsin?
It really depends. That is a loaded question. Absolute minimum is 12 months. The maximum, I've had estates that have been open for 5, 6 years. It's a nightmare in those situations because there's either litigation involved, or there's a situation where there has been a claim or some sort of lawsuit that hasn't been officially finalized. And I've had a number of cases where there's been a wrongful death case. So, for example, a person was riding their bicycle, they were hit by a car and killed instantly. Uh, some of those cases can last a really long time. There's other cases where the insurance companies settle immediately. It depends on how litigious it is. I've got other cases where there's been a class action lawsuit that was pending prior to the person's death, and that person unfortunately didn't get a chance to reap the benefits of that class action lawsuit, and now it's held open, and unfortunately you can't close the probate until that has resolved. At that point, then you can resolve it because it's considered an asset.
So, is excess litigation usually the biggest factor that can make it go faster or slower?
That is true. That is a true statement, I would say.
Okay.
Yes. I mean, the
Yep.
other big thing is taxes. You can't close an estate until you've actually finalized any income taxes, estate taxes. That's another big one, a big hurdle for people. So if somebody passed away in January, say, of, let's just say now, because we're almost into 2026. So let's say they passed away January of 2026, you have to wait until April of the following year in order to file an income tax return. And right there, you're looking at over 12 months of having to keep the estate open in order to resolve that.
Indeed. Yep. All sorts of ways that that this can
Mhm.
slow down. So,
Absolutely.
finally, are there any other types of fees that catch families off guard?
Yes, the attorney's fees catch families off guard. But bigger than that, we have what's known as the probate fees. And if the estate is millions and millions of dollars, there's a percentage that the beneficiaries ultimately would be paying through the estate assets to the probate court. And we call those probate fees. So we have probate fees, attorney fees, accounting fees. And then after that, we would have a PR fee, because 9 times out of 10, the personal representative, also known as the executor, will take their PR fee. because they're doing a lot of work in order to marshal the assets.
Let me ask an obvious question, I think, but is there a super simple planning move that can help most families avoid all this headache?
Absolutely. Trusts are a huge vehicle for families. Naming beneficiaries is excellent. And here in Wisconsin, we have a transfer on death deed that if you own real estate, you could put that into a situation where it avoids probate.
Well, that seems easy. I can just jump online and find that form, right? Is there any problem with that?
Yeah, that form now is getting more and more complicated. Unfortunately, with that form, you're required to do a real estate transfer return, and we also have now the laws are changing because in March 1st, actually, of 2026, they just postponed it. Originally, the federal government imposed, it's called FinCEN, and they imposed this rule uh, back in, I don't know, it must have been 2 years ago because there was a lot of, uh, let's just put it this way, money laundering from other countries. And so they wanted to avoid that. So now titles are going to be strictly scrutinized. So in situations such as TODs and things of that nature, it's going to require you to report to a governmental authority, assuming it goes through. We don't know yet. At this point, there's been a lot of litigation on this topic. There's several people who are fighting this and saying it's illegal to uh, force title companies and attorneys to report social security numbers, date of births, and so forth on this government database. The FinCEN law has been enacted to prevent people who are attempting to launder money. And what it's doing is it's putting the onus and the burden on title companies as well as attorneys. Anybody who has a buyer and it's a cash transaction, or you have a situation where you have a lender who is not approved and actually follows the FinCEN laws, or you have a situation where the buyer is an LLC, meaning the transferor, an LLC, or say they're a trust. In those situations, the government now is asking lawyers and title companies to file specific paperwork uh, collecting that information and giving it to the federal government. So
I can
the
imagine there's
same
a
thing.
little bit of pushback on that one, indeed.
There is. You could arguably say it's a violation of your privacy, but the IRS has everything anyway.
Yeah,
So
that's
does it really, you know?
well,
The whole point is to capture those individuals who are money laundering. So what you need to do is basically report, where did you get this money? How were you
mhm,
able to pay off this $18 million condo in the Hamptons? Where did the
right,
money come from? So
right.
that's essentially what it's doing.
Well, some people think that skipping probate means hiding money or jumping through complicated hoops. Let's stick it under the mattress, right? But what does avoiding probate really look like for everyday folks?
Yes. Well, avoiding probate is great because not only are you saving on attorney's fees, you're saving on accounting fees, you're saving on personal representative fees. Obviously, the trust might have provisions in there dictating that the trustee is able to pay themselves for the time that they expend to put the affairs in order of that grantor settlor. But the beauty of a trust is it's a contract between you and your beneficiaries, and there is absolutely no court that's getting involved. The biggest thing is it's also very invasive. So there's the problem of privacy. When you're doing a probate, the assets are actually there. You have to file what's known as an inventory document. And that document shows how much the person died with, how many
Yeah,
assets they had at the time of their death. So there's no absolutely zero privacy.
yeah,
Everything is, you can see everything online. We have this system, it's called the Wisconsin Circuit Court Access System, where you literally can see everything, including the amount of money that the testator has at the time that they pass away. So
All
it's very
public
invasive.
knowledge. Yeah, no. Well, we're about to wrap up here, but do you have a really quick story that you can share, maybe about a family who did avoid probate, or maybe one who didn't, where what you saw and worked with, didn't work, what everybody learned from that?
I've had multiple stories, good and bad. The good stories obviously is when you properly plan your estate and making sure that all the assets are funded into the trust. Sometimes you have that occasional situation where an asset was acquired after they'd seen me and there were no instructions, obviously, for that other asset, even though I diligently tell clients, if you acquire additional assets, i.e., a condo in Florida or whatever the case might be, you need to make sure that that asset gets put into the trust container. And this actually did happen to one of my clients after they had seen me and prepared their trust, because I always make sure the real estate assets are funded. The money, the properties are put into the trust, so that way we don't have to think about that at the end. So what in that situation, they had bought a condo in Florida 6 years later and had it only in their names. They died in a joint car accident. Both parties died instantly. And unfortunately, that asset, we had to do an ancillary probate, and it wasn't pretty. We had to do that in Florida, and it involved attorney's fees, and involved personal representative fees. It's plus plus plus. It just adds up over time, and honestly, it's not worth the headache. It is better to make sure everything is properly cared for and taken care of.
And it sounds just heart-wrenching as well. So last quick question for listeners who haven't gotten around to estate planning, what's one easy step they could take right now to make things simpler for their loved ones later on?
Well, one thing that I would say is call me. I can help you to get that estate plan going. You need an experienced professional. That is key. Trying to go it alone is not going to work. I had situations where people came into my office with wills. They lived in Wisconsin, and the will had California law on it. It didn't even apply to Wisconsin law, and it didn't have proper witnesses. It didn't have all those bells and whistles that the court is going to dissect and question thoroughly. So they ended up dying intestate because the will was thrown out. It was garbage. So in that situation, it's important to make sure you seek professional assistance with this.
And you are the person for them to contact. And
absolutely, 30 years.
Excellent. And that wraps up today's episode of Law for Life with Georgia. To learn more about attorney Georgia Konstantakis and Konstantakis Law Office, LLC, visit konstantakislaw.com. And thanks for listening. And don't forget, leave a review, and subscribe to the show so you don't miss an episode ever.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.